Greetings everyone, I am Ngabuto Nicholas Mabena. Today, the 15th of May 2025, the High Court of South Africa, Western Cape Division, Cape Town, delivered a judgment. It's a judgment brought by Skullspring Center of Cape Town in respect to refugees and the asylum seekers. There are certain provisions in the Refugees Act that the applicants approached the court, not brought, but approached the court. My English wants to betray me. Approached the courts for the High Court to make a judgment. It's a 42-page judgment. So we will not, in this video now, discuss the entire judgment. Otherwise, some are going to be lost. So I want to try and make it simple as possible for all of us to have an understanding. So we will read just the two parts so that we have an understanding, and then in the next videos, we'll then continue to discuss. We'll also try to get our lawyers to do a summary of the judgment. I know that there are also lawyers that follow this channel. They will greatly assist us in summarizing this so that refugees and asylum seekers will have a better understanding on what this judgment means. As I've already said, it's a matter between Skullspring Center of Cape Town, first the applicant, trustees of the Skullspring Center of Cape Town, second the applicant, and the Minister of Home Affairs, first the respondent, the Director General, Department of Home Affairs, second respondent, the Chief Director of Asylum Seeker Management, Department of Home Affairs, third respondent, the Refugees Appeal Authority, fourth respondent, the Standing Committee for Refugees Affairs, fifth respondent. So the judge in the introduction, Judge J. Cloete, in the introduction, we just want to read the introduction so that we have a better understanding. It says the applicants have approached this court to have certain provisions of the Refugees Act and the regulations promulgated thereunder declared to be unconstitutional and invalid. In the event of the court granting the relief sought, the applicants also seek an interdict against the respondents pending confirmation of our order by the Constitutional Court. And the judge says, I will return to this aspect later. The impeachment provisions which are stated here in the document of the Refugees Act, as well as regulations. The regulations are stated. The applicants assert that their effect is to disbar foreign nationals who wish to seek asylum in South Africa from doing so if they hold an advanced immigration status solely due to their non-compliance with bureaucratic and or procedural requirements. This, they contend, is an unjustifiable violation of the Constitution, as well as the right of non-return entrenched both in international customary law and of the Refugees Act. The application is opposed by the respondents, who also unsuccessfully resisted the applications of the first to fourth amici for their submission. Those that joined as the Friends of the Court are also listed in the document. We did not read out their names. After hearing arguments, the amici were admitted and granted leave to make submissions on the following limited issues as undertaken by them. In the case of the first to third amici, the issue of non-returnable and non-penalization, and in respect of the fourth amicus the impact of the impeached provisions on children. Let me just read the first paragraph on the reasons for admission of the amicus. Says, in terms of Rule 16A subsection 2 of the High Court rules, an interested party in a constitutional issue raised in proceedings before a court may seek admission as an amicus curiae. The Constitutional Court in Force versus Minister of Safety and Security set out the requirements for admission as follows. I will not read that. As I said, that we simply read the introduction so we have an understanding of why the applicants approached the courts, and then let's go to the order granted so that we don't make this video long, and then we discuss also in brief videos the rest of the judgment in separate videos, so to speak. The following order is made. It is declared that sections which are listed of the Refugees Act 130 of 1998 are inconsistent with the Constitution of the Republic of South Africa 1996 and invalid. It is declared that regulations which are stated of the refugee regulations published in GNR 707 Government Gazette, which is dated on 27 November 2019, are inconsistent with the Constitution and invalid. 3. In terms of Section 17, Subsection 2, Subsection A of the Constitution, Paragraph 1 of this order is referred for confirmation or otherwise by the Constitutional Court. 4. The declaration in Paragraph 2 of this order is suspended pending the outcome of the proceedings referred to in Paragraph 3 above. 5. The interim interdict granted in Part A of this application is discharged. 6. The relief sought by the applicants in terms of Section 172, Subsection 2, Subsection B of the Constitution is refused. And 7. The respondents shall pay 80% of the applicant's costs on scale C, jointly and severally, the one paying the others to be absolved, and including the costs of 3 counsel were so employed. So that's the order that has been granted in this judgment delivered on the 15th of May 2025. We will, in the next videos from tomorrow, going through the weekend, discuss this judgment separate in small videos. I mean in small videos, so that we get to understand what this judgment is all about. It means to refugees, asylum seekers, their children. If you are a lawyer or you have read this judgment and you want to share your views, please do so in the comment section. Like this video, subscribe to this YouTube channel. If you are on TikTok, please do follow us. Otherwise, goodbye.